Can you challenge a field sobriety test? Field sobriety tests are made for you to fail. So because they are made for you to fail, you do not have to take them. And there are no consequences with regards to a field sobriety test. Now, what exactly do we mean by a field sobriety test? A field sobriety test, for example, is the nystagmus test, where they go ahead and put a pen or their finger before you and have you follow them. There is a presumption that if there's no smooth pursuit and your eye kind of jags after a specific angle, then that is an indicator that you are under the influence. The other one is the heel-to-toe walk. That is something that you have to walk heel to toe, follow instructions specifically as to how you turn around and do the heel-to-toe walk back. Is that a good indicator of the fact that you're driving under the influence? Not really, because if you make me do that test, I'd fail even sober. So how can you dispute a breathalyzer result in a DUI case? We go into depth into study and making sure that we get evidence of both maintenance and calibration logs of the machines that are used at the time of the arrest. In addition, we look into the certification of the officer that's conducting that test to ensure that they have been properly trained as to the way that the law requires the test be done. If any of those factors are not present, for example, the maintenance and calibration logs tell us that there were problems with the calibration of that machine during the time on, before, or after the arrest, then we can use that to say this test really isn't efficient and should not be held against our client. If the person's not certified, then we can dispute the validity of that test because the person may have not followed protocol. So there was this one case where the machine had a few tests, 3 to 4 tests, where it kept giving much superior than what the sample test should have come up. So what they do when they maintain and calibrate is they'll run a specific sample of a test, and this should render a specific result. Well, this machine kept going up, and it did so for about a month while it was in service until ultimately it was taken out of service. We were able to use that in our case to show the court, to actually discuss with the district attorney how weak their case was against our client. And we were able to get an exhibition of speed charge, which is non-DUI related, because they realized they were not going to be able to use that DUI result. Is it possible to question probable cause of the arrest? When you are the person that is being investigated and at the time of the stop, do not do so. Follow orders. Make sure that you follow procedure or instructions as they are given. It is the attorney who will have the opportunity to review everything that occurred. And if in fact there is a violation of a probable cause, they stopped you without a probable cause for a DUI, we can use that to, 1, reduce charges, but best of cases, to dismiss charges against you, and therefore do not resist at the time of arrest, but allow your attorney to do their job. So what is the role of a witness in DUI cases? There are times when an officer comes upon a case once the driving has occurred. And how did they become aware of this? Well, someone called it in and said, I'm following this person who's weaving from side to side, almost had an accident. And this person keeps following them until the officer comes along. Well, the officer does not have the probable cause to make that arrest based on his personal observations, but the witness can go ahead and assert what they have seen and be the basis or the probable cause for that DUI arrest. If you have any questions with regards to how to fight a DUI, please go ahead and schedule your consultation with Confianza Legal.